Hello and welcome to Bloomberg Quint. You're watching the fine print. Tata Sons and NTT Docomo have decided to bury the hatchet. Tata Sons has agreed that it will not oppose the enforcement of the London arbitral award that had directed it to pay $1.1 billion to Docomo. Docomo has agreed that it will pause the enforcement proceedings against Tata Sons in the US and the UK. But just because Tata Sons and Docomo are now willing to make peace, does it make the payment of $1.18 billion by Tata Sons and transfer of Tata Teleservices shares by Docomo kosher? To answer that question, I have with me independent lawyer Murli Neelkantan. Murli, in the arbitration proceedings and before the Delhi High Court, Tata Sons has argued, and I'm going to read out their argument to you, that no payment can be made in violation of FEMA regulations. It would be against public policy, and that awarding damages would allow Docomo by a roundabout route to enforce a contract which is unenforceable and is in violation of the law. What cannot be done directly cannot be done indirectly. After Docomo won this arbitration, Tata Sons had written to the RBI seeking permission to pay this $1.18 billion, and at that time RBI had written in its letter had turned down this request and said that the shareholding agreement between Tata Sons and Docomo was structured in a manner that its compliance would entail contravening the FEMA provisions. So besides Tata Sons' sudden willingness to pay Docomo, what has changed that it's legal for them to now pay this amount despite RBI's views?
I don't think the change is whether it's become legal or it's become illegal. I don't know what the permission sought was. If the permission that Tata Sons sought from the Reserve Bank was for payment for the shares.
No, they stated we are supposed to pay this amount and Docomo will transfer us the shares. Now you put two and two together and see what it amounts to.
Exactly. I think the way it's been put out now and it's been put out before was that prior to the award, it was just payment for shares. After the award, there's two parts to the payment. One amount for the shares at fair market value, and the other is damages for breach of contract. The RBI can't have a view on the latter. On the former, the law is that if you produce a certificate substantiating fair market value, then the RBI doesn't have to grant any approval. It's just a post-transaction filing.
No, but then it opens the door for everyone to structure the transactions in this fashion that whatever the deficit is, you happen to pay that as damages and, say it's a breach of contract. Then where is the sanctity of RBI's FEMA regulations?
I think there's a big challenge to this, and we've had it for a very long time. If you see a number of agreements, they've tried to get over this with non-compete payments, tried to get over this with royalty payments, transactions that are not on the capital side but on the current account side. So it's not a new idea that we will have some part of it, especially in relation to shares where you have fair market value, and some part of it in a route which is not controlled by the Reserve Bank of India. So this is not a new idea. What is new is that it's come out as damages.
Okay.
They could as well have paid it for any other reason.
The imagery that comes in my head, Murli, is that you don't hold the year straight. You go around about, as mentioned in Tata Sons' argument, and hold the year. However, you characterize it under header 1 or header B. Essentially, shares are changing hands and a payment is being made.
True.
Now you give beautiful names to it. It's still in violation of, I don't know, the letter as well as the spirit of the regulation, right?
Perhaps, but we've made that problem ours in the way we've set out the regulations.
Okay.
The regulations talk particularly about capital account transactions, which is transfer of shares, and not about current account transactions, which are freely
and
available.
you also pointed out another difference between FERA and FEMA in our offline.
So the issue that I was coming to that. So historically, there was a requirement for all payments, virtually all payments. We didn't distinguish between capital account and current account. We had restrictions on both capital account transactions and current account transactions. So, for example, if you want to pay royalties, there's a cap on how much royalty you could pay. But it's a regular daily transaction. If you want to buy shares, there was a regulation. In 1973, every transaction was virtually regulated. With whom you could transact, how much you could transact. Every export, every import was regulated. As a part of that, if you wanted to enforce a foreign judgment in this country, you need RBI approval. And in the Bombay High Court, you couldn't even lodge an execution petition and get leave until the RBI granted approval under Section 47. That changed in FEMA, where we said current account transactions will start liberalizing. Now you might say that's a big loophole. Whether you call something a current account transaction or a capital account transaction is just a matter of nomenclature. It's also an accounting issue. So the amount that will be attributed towards shares and the amount that will be attributed to on the P&L to damages is now going to be an accounting issue. Thanks to the award now, Tata Sons will say we paid only X amount towards the shares,
and why
that goes as in our books on our balance sheet as cost of acquiring these shares, and then we have to make now a payment for damages which goes directly into our P&L. That is a consequence. Whether it is complying with the law or not, with FEMA or not, is very easy because FEMA says you can do it. The question that you are asking is, should Tatas have gone to the Reserve Bank of India to seek this?
No,
having got it now, are they in a situation?
Having gone now and having the RBI on record saying that, look, your SHA was designed in a fashion to, overcome the hurdles of FEMA. Now having to say, or now saying that, as it says in the press release, that if Delhi High Court, the parties have jointly applied to the Delhi High Court requesting to accept their agreed terms of settlement subject to such further orders as the court sees fit. Both the press releases of Tata Sons and Docomo don't mention RBI. Though to be fair, a reporter in the court today mentioned that none of the parties will object to RBI's intervention, but we have RBI's view on record. How are they going to change that?
I don't think either of the parties can change that.
Only RBI can change it.
Only RBI can change its views if it has a different view from what the parties have taken. And it's really up to the High Court now to say that we now have the RBI's views, whatever they may be, as filed next week or the week after, and then decide whether they want to decide this issue or not. I'd be very surprised. It's unprecedented to have RBI file an application of this nature. In all the other judgments and awards that have been enforced in this country, nobody's ever made RBI a party and had them come and take a view on this. It was the courts which had to take a view on whether it was against public policy or not, and didn't defer to the Reserve Bank of India for their opinion on whether it is required or not. So it's a very unusual thing to first invite the Reserve Bank to give their views, and now that you have it, we don't know what to do with it because it could potentially hurt this settlement. So it does put the parties in an uncomfortable position.
And the RBI?
Well, if this is a matter of national interest, then the RBI will probably have to do another U-turn. It's done one and it will do another now.
All right, okay. So let me put out a statement that the Tata Sons petition made in the Delhi High Court, and that in fact makes them look even bad because they say the enforcement of the award would open the floodgates for parties inconvenienced by decisions of empowered regulators in India. All that would be required to ensure the performance of contracts which might be contrary to the provisions of statutes or decisions of regulators would be to have a foreign arbitral award passed in favor of such performance. The authority of all regulators empowered by the legislature and not just the RBI would be completely undermined by the simple expedient of a foreign seated arbitration. Is that a precedent that we are staring at now, Murli?
It's not new. Even under the old FERA, there were transactions which were permitted and the transactions which were not. So if you had a judgment to the extent that it was permitted for an amount to be paid, it wouldn't require RBI approval. To the extent that it required RBI approval, that part of that payment would have to be approved. That was under FERA. Now we've liberalized it. This is not about whether we can circumvent a regulator by going to a foreign arbitral award. The issue really is, what should the regulator have done in the first instance, in the second instance? The challenge is going to be credibility of the regulators by their own actions. It's not the credibility of parties or the foreign arbitrators in this. The question mark really is on credibility of the Reserve Bank of India. And should it have acted differently?
Correct. But also, okay, I take your point that FEMA doesn't currently require permission to be sought by the RBI, but they anyway went ahead and took that permission. RBI denied them that permission.
True.
But this is a public transaction which has,
Yes.
gained headlines,
Yes.
For the last couple of years. Even if that RBI's explicit permission was not needed and RBI is watching this transaction unfold in before it, would then in that case they have not reprimanded the parties and called them to explain that how could this payment be made? Irrespective of the explicit permission.
Therefore, payment was not made. So, to the extent that the information is given to the RBI, the questions that are asked for the RBI to be answered are not in the public domain. So, we don't know in what form the question was asked to the Reserve Bank of India. If the Reserve Bank of India took the view that no, this is really one transaction, irrespective of the award, what you're doing is implementing this agreement. It's missing the nuancing of the law, which is there is a breach of contract, there are damages. To the extent there is fair value for shares, those shares are being given back to you. And to the extent that the shares don't represent value, which is the remainder of the damages, you have to pay that amount. So it is not as if the Reserve Bank is in a position where it is doing something that it was never asked to do. It's in a position which it created for itself. It could have gone back to the parties and said, I don't think you require our approval.
Okay, I know I'm asking you a difficult question. How do you anticipate this will unfold in the Delhi High Court in the next hearing, where RBI is asked for its views? Its views are public, are on record. How will this unfold if the Delhi High Court says, okay, this is all kosher, RBI's FEMA regulations are not being violated? I'm just perplexed. How bad would it reflect on the institution, right?
I think there are many ways the RBI can perhaps stage a comeback here. It can state that the question that was asked of us was, does this whole of this amount present fair market value? We answered that question to say, no, it doesn't. We were asked the question whether or not shares for fair market value is good for fair market value for these shares. And we would have perhaps answered, yes, this amount is. We have no business answering the second part of the question. And perhaps we extended ourselves in answering the second part of the question, should damages be payable or not? That's not our remit. And perhaps we stretched ourselves a little too far to do it. So they can come to court and say the question that's really asked of us is limited to the first part. Do these shares, does the consideration represent fair market value for these shares? And to which all we can say is, so long as there is a certificate, we have no view on it.
So not only will this benefit the existing fact situations like Tata and Docomo, some of which are, before various high courts,
Yes.
It will also then benefit future such contracts, because if the RBI is saying that, oh, we only need a certificate and we are not going to sit in judgment of that fair market value, which is the case today?
Yes, it is the case today that it's a post facto filing with the Reserve Bank of India.
Right.
So if parties agree, and let's assume in this case that parties never went to court.
Right.
Let's assume that this good faith that the Tatas have about honoring their contracts existed on the date of the award. And the Tatas paid the money, got the TTSL shares. The RBI would have no role to play in it. We wouldn't be having this discussion. That's where the majority of the transactions happen. Nobody ever goes and asks RBI, shall I pay? Should I be paying? Typical bureaucrat's answer to any question like that is no. So nobody goes and asks the Reserve Bank of India. They have the paperwork done. It says, here are the shares, here is the form, here's the certificate.
So essentially you're saying today, as a foreign investor, I can have a predetermined exit price and camouflage it in different ways?
If you don't call it a predetermined price,
Yeah,
if you
of course
say,
not.
we will agree a fair market value,
Right.
and we expect it to be in the range of whatever, or we have a formula to say it's X times EBITDA, it's Y times PAT, and that's how we think fair market value should be computed, and that's a reasonably accepted method of valuation, then they will get away with it. So all the restructuring of the options that were done originally with a fixed price were done to call them fair market value. So most of the agreements done at an era where a fixed price option for buying in the future was banned, most agreements had it in a form that was close enough to that number without calling that number out. So you could have a business plan, you could have projections, and then say it will be that number, a multiple of or a factor of those numbers in the business plan. And that's a perfectly reasonable way of doing it. You have discounted free cash flows, you have a formula worked out on that, and that's acceptable. So you could do NAV, you could do DCF. Business plan gives you DCF. Based on that, I have a number, and therefore, anytime in the future, I refer to the business plan, and I get the same number.
So then are we back to a place where RBI has allowed predetermined prices and camouflage it as with various nomenclatures and get away with it? Because that was the problem where it started, and it came into the picture and decided to regulate these put and call options, right?
We've had a history of it, no, Payaswini, because originally we had a very complicated formula. Then we moved to one of either NAV or DCF. Then we said only DCF. Now we said anything that is reasonably accepted. So there has been a liberalization by the RBI to say, we understand that we don't know how to do valuation. We can't have a rule that fits all industries. We can't have a formula or a multiple to say these many times PE or that many times EBITDA. We've agreed with all of that. So we just leave it to the parties to go off and find what is a fair market value. And so long as they can get a professional to certify it, we're not even approving it. We're just being informed.
How difficult will that be? Okay, the other thing I found curious in the Docomo press release was they say that the full satisfaction of the award through the Delhi High Court's judgment will enable Docomo to consider reinvestment of an amount in India under a new cooperative relationship with Tata Sons. Now, we are not privy to the settlement agreement, but I can't stop wondering that if this reinvestment of the amount commitment nudged Tata Sons to make that settlement.
Well, I guess in any settlement, both parties will have to be in a position to come away feeling that they're better than where they were. And I guess in this case, for Tatas to say, yes, we will pay you, would put them in the exact position as on the date of the award. They wouldn't have made any progress. What's their incentive for settling this? Rather than dragging it on for another maybe 5 years.
Right.
So there must be some incentive for them to settle. And perhaps this was the incentive. The other side saying, yes, you owe us 1.18 billion, but we appreciate the gesture and we want to continue doing business with you, and we'll give you back some of that money on some other deal. It might look not as pretty as they would like it to, perhaps, but there must be an incentive on the Tatas to settle. And in the Indian context of litigation, it can go on for a very long time, not see money for a very long time. So the choice would have perhaps been, will you take a haircut or will you reinvest?
Well, cheers to what the Docomo calls a new paradigm for India-Japan economic ties. Thanks, Murli, for coming and sharing your views. And thank you very much for watching. We'll get you the details once the RBI comes before the Delhi High Court with a view and what the Delhi High Court's final judgment on the matter is. Thank you for watching Bloomberg Quint. We'll see you soon.